Hi, Zoom people.
Hi, welcome to our second writing workshop for housekeeping. Our next meeting is next week at 6 same time, and it's our second citation and footnote workshop. If you guys want overview.
Is the audio better now?
Okay, I'll just stand closer so you can hear me. Sorry about that. So yeah, our next deadline is November 16th, and this is the second rough draft. This is just for the print volume. Online volume is obviously, as you said, running on a different schedule. But with this, we really want to see like how far you've come, I guess. And I know that's like what we say with every rough draft that you submit, but we do want to see like a pretty well completed note and just like, like a good understanding of what your argument is going to be. You have an argumentative thesis. You're not just summarizing a lot of the cases that you're looking at. You have a point to the writing. You have like both the background history and then also it's forward looking and the conclusion, stuff like this. And we're going to talk more about what we're looking for in the writers workshop a little bit later, just like more specifically, but yeah, we are looking for, I guess, a more polished rough draft than we were for the first one. Also, do you want to talk about internship?
In the next email, we'll include our like internship database. It's basically just like a Google sheet of previous law-related internships that people in the club have had. And since people are starting to apply to like spring internships, we encourage you guys to look at that database. And then also if you have any internships like poli-sci related, law related, like anything that you think someone in this club would find of interest, definitely feel free to add it and as much information as you can about it. It would really benefit everyone in the club. And then the last thing is we just wanted to draw to all of your attention, since a lot of you are, I think everyone here is writing. If your note is published, which if you're here, you're probably on track to being published, it will be publicly available forever. And yeah, super exciting. But a really important thing to think about is like future jobs that you are applying to, or like law school admissions offices, grad school admissions offices. Some of you might not be at the point where you're thinking about law school and grad school, but if you are thinking about applying to these, you don't want something that is like bad published with your name like available just for anyone to see. And if you have like a publication on your law school resume, chances are if a school is considering you, they'll look it up. And if it's terrible, they might not admit you. So if your note is on track to being bad, don't publish it. Yeah, that's basically it, right?
Okay. Yeah. But that like, I guess, just totally different. I guess, like, your note isn't going to be terrible. It's going to be good. We just had, who were we talking about last night? Amy. Yes. How, like, yeah, her publication in her law review was brought to the attention when she was going through the process of the confirmation process. So like this is something that people are going to be looking at, and we know you're not going to publish something bad. We know that your quality of writing is going to be good, and it is good. We just do want to remind you that this is something that future employers and future law school admissions officers will be able to access. So just keep that in mind as you're working on it. Yeah.
But just make sure that what you're doing is something like you're proud of and you want your name on. It's a lot different than like if you're just submitting a paper for a class, you might not care that much about like if the citations are perfect or if you have a spelling mistake, but like these things matter when it's publicly available. So we just want you guys to keep that in mind as you're writing and editing. So Oh, wait, is that it? Oh, yeah, okay. So with that, we have projected this image before. We just want to draw your attention to it again, and just to have like a logical and methodical argument. A lot of writing that we do for classes, sometimes it feels like a roundabout way of saying your direct point, or like your thesis statement isn't as clear as it normally should be. But we just want to emphasize that in a law review article, it's not necessarily like this amazing like work of like literary art. It's like the point is to be logical and have your readers have a clear understanding of exactly what you're trying to say, the evidence that you provide, and your thesis. So if anything is unclear in your note, you definitely want to try to make it as clear as possible. The point of like a law review note, contrary to some other types of writing, is not to leave open questions. You don't want to like leave the reader questioning what your viewpoint is. You want to take like a firm stance and provide evidence that supports that, and any evidence that you introduce that refutes that, you want to make sure you address it in a very clear way. And the best way to do that is just to provide reasons, objections, counter arguments, and then a final conclusion. And we'll talk about ways to like relate back to your thesis throughout the note, but just emphasizing your thesis and like restating it multiple times throughout your body paragraphs is really beneficial in making sure that you have a very logical argument. So, how do you turn back?
Yeah, so now we're just gonna get into, basically we'll be talking mostly on your introduction and conclusion, but sort of what happens in between for a little bit as well. But introductions are a little bit unique for law review articles, so we're gonna spend a little time going into these and what we wanna see. To start off, just kind of like any paper you write, you wanna have a hook. This could be a pertinent quote, a statistic that grabs the reader's attention, a relevant term that you define that's pertinent to your case, or if you want to pose a question that you're going to then answer in your argument, things like that, obviously. But a couple things I just wanted to point out first. With this, don't be too broad. You don't need to make any sort of grand sort of points about the Constitution or Congress, or kind of these very general broad topics. Basically, your hook, it doesn't need to be your exact thesis or your exact argument, but your reader should have an idea of where you might be going by reading your hook. So make sure it is still relevant. And then take a 2 minutes detailing your particular piece of legislation or your court case that you're going to look at. You will have time in your other sections to go over, an overview of whatever court case you're looking at, whatever precedent. You don't need to go into any explanations of that in your introduction. And then the bulk of these first paragraph of the introduction would be just setting the stage. So going from your hook to what will then be your argument. And so you can take your time with this transition, going each step by kind of what your, like I said, your thought process is, why you're using this, if it's a term, and I'll give an example on the next slide of Caroline's to kind of emphasize what we mean by this, but just going about why that term or why that quote is important to your argument and giving a clear but concise but thorough explanation of that. And then with your second paragraph, it's going to be much more structured, and it's just a roadmap of what your note structure will be. So you can go literally section by section, just summarizing not only what each section of your note will be, but the purpose of having it, what you're trying to achieve by looking at a certain case, what you will be doing then with this precedent in terms of creating an argument about its ramifications, things like that. And you can use language like we say, this note will document, this note will examine. You can use this note, and I think that this is obviously language that is used in a law review, so that's great. But it's also really useful for your reader and for yourself. For your reader, it just really clarifies what you're saying when you concluded your thesis, just saying this note argues that blank. But it's also really good for you make sure, as you're writing this, and I recommend you do this as soon as you can, just an idea of, do the sections that I have for my note, do they make sense in the order that they are now? Can I connect one point to the next, to my thesis? Does it flow well? Do I need all these sections here? What are each one of them adding to what my ultimate thesis is? And then, also just making sure with your thesis, obviously, and we will go into your thesis a bit, but just making sure that you can pinpoint your thesis in one sentence. Yeah, just blatant. And so now So this is Caroline's note. She opens up with a definition of an important term, which is severability, and then goes into, its founding applications in the to kind of explain why it is used to ensure that a piece of legislation is still constitutional by severing a certain part of that legislation. And so first she opens with her definition and also a quote, and then she introduces the subject of her note, which is the Affordable Care Act. And then she concludes this paragraph by connecting them. And so in the second section, the doctrine of severability was evidently crucial in determining the ability of the Affordable Care Act to stand without one of its major provisions. So therefore, she takes severability and her argument and puts them together very succinctly in one sentence, and then goes into her roadmap. And so that is just kind of what we want to see. And then again, like we were saying, making sure that it can have broader implications of your argument that you can maybe go into in the conclusion, but to really keep this about your legal argument and why what you're saying is relevant to a legal scope of whatever your issue is. And so then we go over the thesis. So for this, it'll be the very introduction, just one sentence, stating it clearly, this note will argue is perfectly fine. We just want to again say that it can be as assertive as possible. I think, obviously, as you're still researching and deciding what your structure is, what your argument will be, you might have your thesis right now saying, oh, this note will make an argument about, or this note will the issue of. But really, when you have your final thesis, you want to state what that argument will be, or you want to state what the exploration of that issue results in. So be as clear as possible with this as you can, and really take an opinion. You obviously, we don't want biased language, but you want it to be argumentative language. So, if you disagree with it, hide that in some sort of kind of hesitancy that you can just state that clearly. And so we just want to make that as direct as possible. And so these are just a couple examples that show one sentence theses.
There's a clear distinction between being biased and being assertive. In this case, we really warn against biased language in terms of you don't have enough evidence to back up what you're saying. If you're making a legal argument, chances are it's about a political topic or a politically divisive topic. And we understand that your position that you're taking might be a position of a major political party or major politicians, and that's okay. That's not necessarily biased as long as you have the proper evidence, cases, legislation, data to back that up. Whatever type of evidence you use is up to you and what you think your note is about. But it's not necessarily biased if you have enough information to back it up and you're making your conclusions based on the evidence, not your predisposed assumptions of the topic.
Yeah, so for the next draft deadline, obviously, like we said, we want to see a finished rough draft. But at this point, I know you're also working on this, but ideally you should be able to finish the sentence, this note argues. And then also I would just point out, obviously you maybe haven't done your roadmap yet if you're not familiar with what that looks like. But you should be able to have a structure at this point where you can kind of easily just work out what that roadmap will look like. And even if you don't use this note argues as your exact language, this is always a great starting point just to get out what you want to say in one sentence.
We just have like a little checklist here for your introduction. We're recording this presentation as well, so it will be available on YouTube. But we are just like, the main questions are the first few sentences interesting? Does the introduction provide context for the thesis statement? Is the second paragraph a roadmap? Is the roadmap accurate? That's something that it might seem like it's kind of insignificant now, but we've gotten notes before where the roadmap in the introduction is like literally not what the note does. And it's clear that the writer probably wrote the roadmap and then edited their note. So you want to just make sure that like your roadmap is actually completely accurate in what the order of your note is. Is the introduction concise? I think usually like it's around a page. And then does the introduction clearly state the thesis? Like we said, literally the last sentence, this note argues, this note concludes, this note asserts. You can basically use any synonym of the word argue and it will work. Yeah.
Just make sure that you reiterate the point you're trying to make. I think obviously it's easy to reading something like that. What you're asking. So the easiest way to do this is just how to be relevant to your ability clearly points on writing into your present you have bringing them together, but also that you're explaining them. We recommend putting in quotes of an entire sentence, really giving context to them, why you're including them. I think it's also just really a good test for yourself. If you're asking, so why, so it doesn't actually answer my argument or my thinking anyway, then you can take it out and you don't need it. It doesn't add anything. And then lastly, we're going to talk about so first, very briefly, you just restate your thesis and some key points. This does not need to be drawn out, and I also pointed out it does not need to use the this note language. You don't need to say this note will because you already did. This is the end. So you can just sort of almost work backwards from your roadmap. Just give a brief explanation of what your main argument is, and then a couple really important points about it. But the most important thing with your conclusion, which is maybe unlike what you do in a regular research paper, is that you're really trying to then look at the next steps and be forward thinking about this. So, you know, you can ask yourself these questions. Why does your argument matter in the long term? You know, really thinking about what, if you're arguing for a change in precedent, what would that mean then for other cases, for future legislation, things like that. And I know with Caroline's, she talked about severability and the importance of the Supreme Court in the sense that in theory versus practice, the legislative body, Congress, they often don't get things passed, and so things will fall in the Supreme Court. And so if they can use something like severability, then it is then a solution as to just having there be no resolution on this piece of legislation and having it not pass, and not having that addressed at all. And so kind of saying what the implications are, what its impact is, and she then related it to a different case, Shelby County, pointing out how that was sort of a failure and that Congress never really resolved the issues that the Supreme Court pointed out with this. So really just bringing in these other arguments that you could use. And I also would say, you know, obviously your main note will be your legal argument, but if there is a kind of broader social implication that you want to bring up that just doesn't fit into it, you can bring that in here, and really just kind of ask yourself, if the specific topic you are discussing no longer matter to anyone at all, how would your argument still be relevant to the legal community? So basically, if what you're talking about is something very pertinent to a current issue, whatever argument you're making about that, if it is still relevant, even like 10 years from now, beyond whatever's happening in the moment, if it's still relevant, then that is great. And that means that it's still relevant to the legal community. So really just making sure you're looking ahead, and you're kind of addressing these other implications of what you're saying beyond just the more narrow constraints of your argument, if that makes sense. Does anybody have questions about this so far? No?
So 20 years from now, the Affordable Care Act doesn't matter at all. What did my notes say that would be useful to people reading it, considering the Affordable Care Act like never existed? And that's what your conclusion should do. It's a really difficult thing to do. It's difficult to think about like broad implications after you've done all of this very specific research. But when you have like free time, or if you're thinking about it, if you have any random ideas, just write them down like in a bullet point, and then you can come back to it, or we can help you like figure out how to word it in your conclusion. But that's just the best way to think about it, is like if your particular topic, the legislation, the court case, the situation just literally didn't matter to anyone, like why should someone still read your note, and what would it tell them about a broader like legal argument?
Yeah, and I'll also say too, you know, obviously it's fine to kind of, I know one of the examples we used earlier was on United. If you are say disagreeing with a court case like that, and then you want to maybe in your argument you're not actually presenting a solution to that, you know, in your conclusion or in your last sections at least, it's always good to then provide a little bit of context of maybe what some of the alternatives are, to kind of bring this into reality of what we can actually do about this if you are in your argument presenting an issue. So then we just have a
yeah, so similar to the introduction, we just have a conclusion checklist. So does the conclusion remind the reader of the questions the note sets out to solve? Does the conclusion incorporate aspects of the introduction to give the reader closure? Does the conclusion restate the thesis? And is the conclusion forward-looking? So generally, if you have like a 2-paragraph conclusion, you might want to do like the first paragraph is like a summary kind of, and then the second paragraph is forward-looking. Sometimes if you have like a lot of like forward-looking points, you might want to separate that into 2 paragraphs, but that just depends on what you can come up with. and the way you want to word it.
And then we're just gonna finish up with some last tips in general here. The first one, I'm pretty sure we are all guilty of using block quotes. But let's be real, like this is the same thing as having like annotated like footnotes in like something you read for class, like you never read that. So just assume that your reader will not read that. If you have important information, your block quote, it's much better to just paraphrase or quote part of it and then kind of go into detail and explain it yourself. Use transition words. I know it's, you know, kind of hard to fit all this information into a certain section, but just make sure that it doesn't feel kind of clunky going from one thing to the next, and really explain why they all are relevant to each other and to your argument. And avoid long sentences. And I would also say, yeah, using words and phrases, you know, this is a law review, so that may have some sort of connotations with it, but we want to make it as easy to read as possible. So your readers should be able to understand, and it shouldn't be like crazy wordy or crazy long, because I know if I ever read anything for classes like that, it is really tiring. And I will say though, with words and phrases that people wouldn't know, if there are obviously terms, like we've said in the past, that are relevant to your argument that the general person would not know, then go ahead and explain it in the context of your note, and just provide that foundation so that they know what it is going forward. And then use subsections as your organizational purpose. So obviously you'll have a table of contents for your note. And so this is really useful for you just to figure out what your structure is going to be. And it gives you a good chance to figure out what the different points of your argument are and laying them all out clearly. You can use subheadings if you want to sort of break this up even further. Basically, you know, if you have a larger case that you're looking at and you have several different points that you want to make about different sections or different issues that you're looking at with it, then you can go ahead and separate that out so it's easier for your brain to understand, but also for the reader as they're going through it. And then using topic sentences at the beginning of each paragraph. This is pretty standard, but you know, just make sure that you not only present the information, but just set the tone for what that paragraph will be so the reader can know what to expect. And yeah, with those sections too, making sure your titles are descriptive and accurate. You know, it doesn't have to just always be the name of the case or the legislation. You can provide a little bit more context if it's an overview, if it's the implications of, or if it's, you know, the rebuttal of, things like that, just kind of giving some context of what that will be. And then obviously making sure, you know, with the first rough draft, we did not require you to have full citations, but we want to start getting that in the process for these next drafts. So just making sure that you at least make note of where to be citing things, and you should just cite anything that is not your opinion. It is completely normal to have every single sentence in your sections have a footnote on it. That is totally normal. So yeah. You have anything else to add?
As we said, just the most important thing is to be clear and logical. Like for example, section titles. If you can think of like a super creative section title that's actually really descriptive, by all means use that. But sometimes the most effective section titles are like overview of Shelby County versus Holder, and like just flat out saying what it is. I'm sure if you guys have read like articles or done research for classes, you've noticed that things like subsection titles that are clear and just tell you exactly what the section is about actually make it a lot easier to understand the article than like trying to be all like creative and like unclear and then like summarize it all at the end. Like that it doesn't really work, honestly. Especially for like our context of like the law review is supposed to provide an analysis of law, and especially at the law school level, like further the law. And we want to be as clear as possible when we're doing that so people don't confuse what we're arguing for. Yeah, so I think that's it. The upcoming deadlines, November 16th. That's for print. Online people, if you want to keep that, if you want to continue doing the print deadlines to keep yourself on track, definitely do that. The final draft is due November 30th. I think that's like the Tuesday after Thanksgiving. Yeah. Yeah. So if anyone has any questions, we'll all be here for the couple minutes after the meeting, and anyone on Zoom, I'll keep the Zoom open if you have any questions you want to type in the chat. Otherwise, you guys are free to go, or if you want to like talk to each other about your arguments, that's good. But yeah, come up to us if you have any questions. Thanks for coming.